Room is filling up pretty quickly, so why don't we kick things off? Good afternoon, everyone, and thank you again for joining us today. My name is Michael Chumakov. I'm the Director of Wealth Management here at Alterna. It's great to welcome everyone back after this little summer hiatus that we took. We are very excited to kick off this fall season with the next session in our Alterna Wealth webinar series. Today's topic, I believe, is both practical and personal. It's called Powers of Attorney, as you can see on your screen. It's not always easy to think about what might happen if we're unable to make decisions for ourselves, but having a plan in place can make all the difference, both for your property, for your well-being, and also for your loved ones. Whether you're supporting aging parents or planning for your own future or simply curious about how powers of attorneys work, today's session is designed to give you a bit of clarity and hopefully some confidence as well. Before we kick off, I'd like to go over a few housekeeping notes as we always do. First and foremost, all participants will remain in listen-only mode during the entire session. If you do have questions, please submit them using the chat box on your screen. However, we have received a large number of questions in advance. Thank you very much for that. But due to time constraints, we'll have to limit our question period to about 15 to 20 minutes toward the end of the session. We will focus on questions that are general in nature, as we're unable to address personal questions or case-specific scenarios in this format of webinar. If your question isn't answered during today's session, please do feel free to email us at wealth@alterna.ca, and we will follow up with you directly. And lastly, today's session is being recorded, and it will be available up on our website shortly after the session with additional resources emailed as well. So now I'd like to introduce our guest speaker. We're once again joined by Doug Carroll, who will walk us through the essentials in today's session, what powers of attorneys are, how they're used, and what to consider when naming someone to act on your behalf. For those of you who aren't familiar with Doug, I'll give you a bit of background on him. Doug Carroll is the tax and estate specialist for Visa Wealth, a wealth management partner to credit unions across Canada. He brings extensive experience to the table, having previously run an estate planning law practice and serving as an advanced case consultant with both a life insurer and a mutual fund provider. Doug's impressive credentials include a business degree, a Master of Law specializing in tax, and certifications as a certified financial planner and trust and estate practitioner. With over 30 years of experience, Doug supports financial advisors in many ways, from writing articles to providing individual case consultations, and of course, hosting webinars like the one we're doing today. Without any further ado, Doug, I'll hand it over to you.
Okay. Thank you, Michael. And actually, I'm looking at my slide that's up here on the screen here and realize that I was probably doing some editing of a couple of my PowerPoints, and the subtitle here doesn't really make any sense. Your capacity, care, and continuity. That's the subtitle, and then somehow I've got that extra word decumulation in there. So everyone ignore that word decumulation. Although the next time that we're having a session on retirement income decumulation, then you'll know where that came from. So we're going to focus our attention here on powers of attorney, and I'm going to take you through a variety of topics. Uh, I've got 10 topics here showing to walk you through. As Michael said, we'll be happy to deal with some questions as we get towards the end of this. And I think that the majority of the core fundamental questions will be answered by the content that I take you through here. So with that, I will go right into the topics. There are no additional slides beyond the 10 that are here, and there's not a ton of text on them either. This is pretty much as much as you're going to see on the text on the slides. And I'll start off just going to move this so I can get a better look at things. Just to start off to give you some background on powers of attorney as an area of law. Powers of attorney exists in law as judge-made or common law for many centuries, and the judge-made law then forms the basis for a lot of the law that applies in our system. The legislation that provinces have enacted then either amends or replaces the common law, the judge-made law. So powers of attorney existed, again, going back a very long period of time. They had the effect of allowing someone to give someone else authority to make decisions about the grantor, the person who is making out the power of attorney. The grantor having property, giving someone else authority to make decisions about that property, which might be managing that property, perhaps while the individual was physically away. If you go back a century or two, if someone was traveling a fair distance, then we didn't have anything like the kind of communications we have today, and so having someone who could keep an eye on things is quite important to do. Uh, the nature of those powers of attorney was strictly for property purposes, and then today, through the province's authority, when I say provinces, under our constitution, property matters in particular are the responsibility of the provinces as opposed to the federal government. And the ability to name someone as an attorney, both for property purposes and for personal care, is something that falls to the provinces. So the idea of naming someone as an attorney under power of attorney is that you're extending decision-making ability to someone else, and it can be more than one. I'll talk a bit about that further on, more than one person. You're extending decision-making ability to someone or more than one person who then will be able to make decisions if you're not able to do that yourself or you're not physically present when those types of decisions have to be made. By making out a power of attorney, by naming someone as your attorney, you don't lose your own ability to make decisions about your property or about yourself. If we're talking about the personal care decision making, you are adding someone else who can make decisions for you as and when necessary. The person you name as your attorney is considered to be a fiduciary. The term fiduciary is a little bit overused in the general media and general conversation. It seems very watered down at times that everyone claims to be a fiduciary without really knowing what a fiduciary is sometimes. A fiduciary is someone who has either knowledge or powers where someone else, it might be more than one other person beyond the context of powers of attorney, someone else depends on that individual to act in the best interests of the subject person. So with a power of attorney, you're giving someone authority to make very significant legal decisions that affect your interests and affect you personally. So the person named as the attorney must always be acting in your best interests. I have both the term grantor and donor showing here because depending on province or other jurisdictions, the term of the person who is making out the document is either the grantor or the donor. In Ontario, grantor is the term that we see in the legislation. It's something where you, as the person who would like to extend out that authority, make a decision to name someone else. So it's voluntary for you to do that. You don't have to do it. Generally, as part of estate planning, broadly speaking, estate planning. So we're not equating estate planning to strictly making out a will or being concerned about what happens after a person's death. The position at that point is everything that you own then transfers over to your estate after your death. So when I say estate planning here and powers of attorney is part of estate planning, I'm talking broadly about taking care of yourself during the course of your lifetime, as well as looking out at the distribution of your property after the point of your death, or even during the course of your life, looking at who you want to take care of, including yourself during the course of your life. So powers of attorney are really critical documents. The power of attorney for property, the power of attorney for personal care, and the person's will are the core documents that are involved in estate planning that you get to through the course of having an engagement with a lawyer, an estate planning lawyer. They're not necessarily the only things that you do. It may be that other steps are taken or at least considered that might have an alternative approach to dealing with identified issues, or might be the things that that you have a trade-off based on circumstances that you do those other things. But the power of attorney and the two powers of attorney in the will, those three documents are really the core of what you see as a physical document that comes out of an estate planning engagement. The comparative with you making the voluntary act of naming someone as your attorney is where a court is required to step in because a person is incapable of making decisions themselves. In that case, a court may appoint someone as a guardian over a person, like over their decisions about themselves and their own body, their own needs, as well as potentially a guardian over that person's property. So those are court appointments, not you doing that. The other term that is historically it's existed in some provinces, still exists in some provinces, is the term committeeship, and that is the emphasis. It's not committeeship; it's committeeship, where a court would step in and name someone as the committee for someone. For practical purposes, certainly for our discussion here today, just I'm going to leave this behind anyhow after this. A committeeship and a guardianship are pretty much the same thing by different name, according to the jurisdiction where the decision is made to give the order by a judge for either the one or the other, a guardianship in some provinces and committeeship in others. So I've already referred to the distinction, the main distinction between the two types of powers of attorney: property power of attorney and personal care decision making attorney. And I'll go deeper on each of those following, but I just wanted to deal with them together in the same place here to talk about the distinction between the two before dealing in a little bit more detail with each distinctive from one another. With a property power of attorney, you can have a power of attorney that is either a general power of attorney that covers everything that you own for all time, if that's the way that the document is executed. And when I say all time, when you make out a power of attorney, you do have the ability to revoke that power of attorney. As a practical matter, sometimes that may be challenging if there is a physical document which you've lost control of, lost track of. You need to actually give notice to anyone who would otherwise be taking instructions from the purported attorney that, in fact, you are revoking that document. The best way to revoke the document is to destroy it, and so you have to bear that in mind, that you are giving significant authority to someone who may very well, to your benefit, have represented themselves out on your behalf. And the people to whom those representations have been made and the organizations, they need to be alerted if you are revoking that document. So the nature of a power of attorney can be that broad, general, all of my property, or it can be specific. It can be strictly, and I've used this example for decades. Uh, I used to, long, long ago, I used to own a condominium when I was living out in Vancouver, and I moved back to Ontario. The real estate market wasn't in great shape at the time, and so I continued to own that and rent it out. My sister lived in the area, so I made out a power of attorney where, if decisions had to be made, particularly if the property manager needed some instruction with tenants, then she was there on the ground to be able to do that. I was at the other end of the phone line, I guess, but this was about 35 years ago, so phones were kind of dial up at that point. It was more convenient to have her on the ground to make those decisions. So specific to that piece of property, that condominium, she had power of attorney, but only for that. So it was a very specific power of attorney. We also have a distinction between powers of attorney that cease to be effective if a person becomes incapable. Under the common law, the judge-made law, it was the case that powers of attorney in that under those that regime. If a person who is a grantor of power of attorney ceased to be capable of making decisions themselves, then any powers of attorney the person had given also ceased to be effective. Well, in today's modern society, that's really the time when we often want for the attorney to be able to step in and act when it is that the grantor becomes incapable, whether that is because of declining capacity, a mental condition that the person has, something that might be associated with advancing age, understanding that just because someone has advancing age, that does not necessarily equate to a reduction or a total incapacity. It may be that someone becomes unconscious through an accident of some sort or some medical condition, and in that case, the person who is named as the attorney, we want them to act at that point. So the terms that we hear now from through the legislation is that we can also make out continuing, enduring, or durable powers of attorney. These are all property types of powers of attorney that we tend to hear have these phrases attached to, where in the power of attorney document, we can state in there that if I become incapable, then I allow for my attorney to act on my behalf at that time. So I'm allowing it to continue past my own incapacity. It depends on your preference and how you're advised by your lawyer, whether you want to set up the power of attorney to be able to act immediately and continue on past your capacity, or if maybe there is some later event which allows them to take on that responsibility and that authority. I'll talk a little bit about that a little further on. The other type of power of attorney for personal care decision making, and again, for Ontario, it is referred to as the power of attorney for personal care. In other provinces and other jurisdictions, they might have a different way that they refer to this, and the scope of the authority might be different as well. It does vary somewhat from one place to the next. It's similar, but there are some variations on it. But with this power of attorney for personal care, it does include medical consent, and that's usually where people tend to think about this is, oh, is that the pull the plug thing? Is that the do not resuscitate, perhaps? Well, medical consent covers all sorts of things, administering treatment, prescriptions, allowing for those things to happen, as well as perhaps end of life decision making if the person cannot respond on their own behalf. But it's much broader than that. It goes into things having to do with your general health care, your social arrangements, going to appointments, particularly doctor's appointments, nutrition, shelter, your clothing, uh, just generally taking care of you as opposed to the things that you have. So going a little bit more into that about you, the medical and the personal decision making under the power of attorney for personal care, in order for you to be able to be a grantor of a power of attorney, so to give someone else authority over you for personal care decision making, you have to have the capacity to understand the nature of the decisions that are being made for you, the responsibility that the person has towards you, and the authority that you are granting to them. And the age to be able to grant the power of attorney for personal care is age 16. The power of attorney for property is age 18. And in other provinces, it may be, again, a little bit younger age for personal care decision making as opposed to property matters. The distinction should be made between this power of attorney for personal care and other phrases, other documents by different phrasing, such as a healthcare directive, a living will, an advanced care directive, an advanced healthcare directive. So, combination of those words. Those are are documents that can be executed where you are giving someone guidance on what types of treatment you would want to have for yourself given a certain situation if you can't express that aloud or consciously at that time, that you would either want or not want for yourself at that point. That has to do with the treatment as opposed to who has the legal authority to give consent, to give guidance and instruction. In some provinces, the term living will is synonymous with the naming of someone as an attorney. But in Ontario, the distinction is made between the person who you name as your attorney for personal care and an advanced care directive. And the term advanced care directive, again, all its variations, it is covered in the Substitute Decisions Act, which is the core legislation, Ontario legislation that deals with these things, as well as the Consent to Treatment Act. Uh, the the uh, the the combination of the living will type of statement or health directive and the power to make the decisions means that within the power of attorney for personal care, quite often there will be general statements that will appear there in a lawyer's documents for use for this purpose. There will be general statements as to the intended scope of authority of the person, and there might be very specific statements. So if you, for example, have a distinctive medical condition, and I'll just pull this out of the air, there are three common treatments or available treatments that might happen with that condition, and you have had the experience, certainly you've had the chance to look into for your own needs the three treatments, and your preference among them is A rather than B and C, or maybe you just do not want C at all. You could state something of that nature in the power of attorney for personal care. The person who you name as your attorney must take that into consideration. It can't be a full directive to that person that they cannot in all circumstances, because there could be some type of development or condition at that point of time where a decision has to be made, where your instruction perhaps did not anticipate the variation of the circumstances, and therefore could not be taken as an absolute direction. But generally, where you have made some type of a statement, whether it is in the power of attorney for personal care as a distinctive document that you have written out, whether on formal documentation or even handwritten or stated aloud verbally, all of those things must be taken into consideration by the attorney when making decisions. So you can see where the person who is named as attorney has a lot of responsibility and potentially complication on how it is that they carry out their job. So I've listed then the types of areas: medical consent, healthcare, that we're familiar with, as well as those things that are more of a day-to-day type of thing: shelter, where you're going to live, transportation to and from whatever needs you have, as well as nutrition, clothing, hygiene, and safety. Those are the types of things that are dealt with under the power of attorney for personal care. Then we have the power of attorney for property. So as opposed to who, you, it's what, or the what you have, the things that you have, that we're talking about here. You need to have, in order to execute a power of attorney for property, you need to have an understanding of the nature of your property, the legal and moral obligations to those people around you, those to whom you have a legal obligation, dependents of yours or close connections of yours, as well as an understanding of the nature of a power of attorney, what it does as a document, and that the person who you name to carry out the responsibility potentially could misuse, just because they're not familiar with what they're supposed to do, or abuse the authority that you are giving to them. So that's the requirement. In in some cases, it may be that um, you have a document that's been executed, because you don't have to use a lawyer to do these things. You can have a document that's been executed, even if it's been done with proper witnessing, which requires two witnesses, and you have to have prescribed terms in the power of attorney for property as well as personal care. I should mention on the other one that there are prescribed terms under terms, but I mean is phrasing that must be in the document in order for it to be effective as a document. It might have those things, but the execution of that document perhaps was not done with the guidance of a lawyer. So it may be that the question arises: did this person really understand the nature of the authority that was being given to someone who then either misuses or abuses? Or even if there's no misuse or abuse, whether the document in fact is effective, because there it might be brought into question whether the person who is the grantor really understands what this is all about. Now that might sound really paternalistic to say that the big brother government is looking over the shoulder of all of us and saying, "Oh, you're not allowed to do those things." But I can tell you from my experience in law practice, and I haven't run practice, it's been 15 years or so since I ran practice, but my practice was principally estate planning that I was doing, generally with small business owners about succession of their businesses, but more generally estate planning where I would see people in their homes, particularly elderly people who really couldn't get out, had a number of clients of that nature. I would have conversations regularly with people who had completely different ideas about what a power of attorney is and does, and had the kind of a confusion of what it is that a will does, what it is that an attorney does, the power of attorney document, and an attorney, the executor of a will who carries out the authority after you died, versus someone who is acting under a power of attorney. Very often, people would have a an incorrect idea about how these things would operate. Pretty harmless, incorrect idea, but incorrect nonetheless. So if that's brought into question for the benefit of people who might do things that they think are going to help them, but perhaps are doing things by their own hand, executing a document that may not actually be to their benefit. That's why there is such stringent rule that says a person has to know these things, understand these things, in order to be deemed to have had the capacity, not just the capacity to be able to execute the document, but to have done so with the appropriate understanding of what the document would give effect to at that time. So that's what you need to have as the both the age and the state of mind in order to execute these documents, and particularly here the power of attorney for property. The person you name as your attorney, unless you put constraints in there that limits this, the person can do anything that you can do with property, your property, with the exception that the attorney cannot make a will on your behalf, a will being something that deals with your property at the point of your death and distributes your property at the point of death, nor can that person revoke a will. And that includes that the person you name as the attorney cannot make beneficiary designations on insurance or registered plans, nor can they revoke those things. Now, there are some practical continuation allowances that can happen with beneficiary designations, like, for example, where you have someone who has an RSP and then passes the age when it has to move over, either be cashed out or move over into so an RSP being a registered retirement savings plan that accumulates tax sheltered savings, and then a registered retirement income fund, which is a decumulation vehicle. Once you hit age 71, then you have to generally move from RSP over to RIF. The the RSP, the person may have made a beneficiary designation on that, and then the RIF is a new plan. Most financial institutions, and you have to check with your financial institution that they are comfortable with this, most financial institutions will allow for the continuation of the same beneficiary designation from the existing plan over to the continuation to the new plan, but would not allow you as the attorney to make a new designation of some sort. No matter what kind of case you could make that there's been a change in circumstance, you're executing or you're attempting to execute an action which was not directly in the contemplation of the grantor. And so that's not something that is allowed, is making a beneficiary designation that would change things. The attorney, the scope of the power of attorney does apply to any property owned by the person wherever it might be. And that includes property that might be in a foreign jurisdiction, including real estate. So it could be personal movable property that's in the other place, and it could also be real estate. Movable property is usually not too much of a problem. I mean, unless we've got battling factions of a family, and we've got somebody who's incapacitated, where there's a lot of legal action, or at least conflict of a personal nature that's going on. Usually, personal movable property is not really much of a problem. With real estate, though, it can be much more challenging because the foreign jurisdiction, and when I say foreign, I do mean a different country, but it also could be a little more complicated when you're dealing province to province, even. The foreign jurisdiction might have its own rules on who can make commitments, who can get access to documents and information, can sell property, who's got obligations for tax filings, those types of things. It may be that the person who named as attorney, despite having apparent legal authority to do those things, needs to go through extra steps in order to deal with that property in those other jurisdictions. And that's why it's quite often recommended by lawyers to say, if you've got property in Arizona, let's say, then it's a good idea to have your core documents, your will and your powers of attorney, in your home jurisdiction here in Ontario, and have a wills and powers of attorney also in that jurisdiction, but specific to the property that is in that jurisdiction, and have those documents drafted by a lawyer in that jurisdiction to make sure that and things are as covered as possible so that you don't end up with further complications. If you want to, with the power of attorney, you can give further guidance and constraints of what you would like for the attorney to do, as opposed to just general authority given to that person. That's up to you. To have lots of extra instruction might not be practical. I haven't seen it or hadn't seen it. I can't say that I've dealt with this on a regular client basis anytime recently, but I'd never seen it where it was anything really complicated, unless it was a specific distinctive property, like a cottage, for example, that there was some preferences that were expressed. And if it got too detailed, then I would usually say, I really am not comfortable with giving detailed instruction of something where it's just speculation how this will be dealt with out there in the future. Let's talk it through. And in documents that I drafted, I never had anything of that nature beyond just general statements, guidance, suggestions of how things might be dealt with. In terms of the operation of the power of attorney, the time when the document comes into effect, executing a power of attorney, so filling out the document so that it's legally effective, that is something which generally requires two witnesses, independent of so it should not be family members who are witnesses. I'm not going to get into all the different requirements of witnesses, but it generally is cleanest where it is people who are at arm's length from the grantor, people who have no direct personal interest in this person's affairs. Having those two witnesses be present while the document's being executed, all three being together. The document may be effective immediately on the face of it. It may say right there, this document is effective right now. It may be that it is deferred until some later point in time, as I was referring to, and I'll talk about the springing point again down near the bottom as I come to it here. But it could be that it's immediately effective, but the intention is that it not be used until some later point in time. The challenges that you run into with revocation, one, you can revoke, as I said earlier, you can revoke as long as you have capacity at the time when you intend to revoke, you can state that you revoke that document. Or if you make out a new document and in the new one it states that any previous ones are revoked, then it will revoke those previous ones. It still is a challenge, or potentially can be a challenge, if you've lost track of those documents and the person acting as your attorney has been operating under those and you no longer want them to do that. That is something that I'd seen. I won't say it happens all the time. Hopefully it doesn't happen all the time, but I'd seen that on a few occasions where there had been a difference of opinion on a kind basis, or a complete falling out between a person who is the grantor and the person who is named as the attorney. It's not uncommon that that might be the adult child of an elderly person, and the adult child having dealt with different organizations, banking in particular, on behalf of the grantor, might have a close relationship or a familiar relationship, anyhow, with the organizations and individuals on behalf of the grantor. And this might have lasted for many years. To revoke something of that nature, you'd have to be very clear that this person no longer has authority to act on your behalf. And so you'd have to then follow that through. Get the original documents if you don't have it in your hands directly, and make sure that all of the organizations and individuals who rightly had believed that they could take instruction from this person, that they now no longer can if you're going to revoke the document. You also have the possibility of resignation, that the person named as the attorney can just decide that they do not want to do this anymore during the time when the grantor is capable. Then that's just something between that person and the grantor. If that person has clearly become incapable of managing their own affairs, then it might require a more detailed process, a more formalized process, and involvement of the courts in order for the person who has been acting on behalf of an incapacitated grantor to then be released from continuing to act, because the person who would otherwise be able to release them is not capable at that point. And so moving away from having the responsibility to continue on is something that may require a court to give permission to do. The documents, as I mentioned earlier, the documents do need to be in writing and witnessed. And I think I covered off the possibility of being immediately effective, or being at a later point in time, or within a certain time frame that they're only operated. The idea of springing attorneys, they sound like a great idea, that you only want the person who you name to step in and do these things once you're unable to do these things yourself. But you generally want to have the person be able to act as quickly as possible in an urgent situation. If there's too much bureaucracy involved in them being able to do that, then it could impede them being able to do that in an effective way. So keep that in mind. Some provinces do have specific springing power of attorney provisions. Manitoba, in particular, I'm familiar with because I was looking at it fairly recently. You can only do a springing power of attorney where you have a lawyer who is the witness, and then the lawyer is under an obligation to do certain things in order to allow for that springing power of attorney to then come into force. So again, the belief and expectation you have of that kind of a use of powers of attorney, it might be tempered a bit by the practicality of trying to have that come into to effect. In terms of who might be appropriate, the person who is named as attorney, it is important that the person be around at the time when they're needed to do these things, which might not be 5, 10, 20 years from now. But it is something where when someone becomes incapacitated, the attorney might be required on a very regular basis, particularly if you're talking about an attorney for personal care and you've got a senior who has regular hospital or doctor's visits. Then that attorney may not personally have to be there at all those things, but they have the responsibility to arrange for those things and oversee those things. So, is the person who is contemplated willing to do it and has the time and availability, doesn't have other responsibilities, either because they have other family or business or employment obligations, or they are physically too far away to practically do it? Is the person familiar with you and the needs that you have? Do they have financial expertise when you talk about property matters? That person does not have to be a financial advisor, an accountant, but will be dealing with matters that are businessy, that affect your finances. And so, someone with that type of expertise might be helpful, or somebody who is willing to engage that expertise to make sure that they're giving the right decisions. Being conscientious and organized are just helpful, so that the activities can be tracked and monitored if necessary. And somebody who is, in the generic sense, trustworthy, diplomatic in communications will allow for there to be more comfort that things will not end up in conflict. Quite often, yep,
Doug, just wanted to jump in, just give a time check. It's for
yep.
20 minutes left in the webinar, so I just wanted to make sure that we leave enough time for some questions, okay?
Yeah, so I'll deal with this really quickly, and then the one last point, and then we'll jump on the questions. So the
Perfect.
question quite often comes up: is one person better? Is multiple better? The most efficient way is to have a committee of one, certainly. To have some oversight, having multiple attorneys does make some sense. Uh, Having more than two or three can become really practically difficult to do. So just bear those things in mind. There's no right wrong with these things, but I would say having lots of people who are potentially going to act as attorney might be challenging. If you are naming multiple people, then either they are to act jointly, as in they must agree on everything entirely together. It could be that it's joint and several, where any one of them can act on your behalf, and that allows for them to step in at different times if necessary. And if there's multiple people involved, it might be that you have a decision rule, like my eldest daughter, if she doesn't agree with the other one or two, then it goes with my eldest daughter, something of that nature, or majority rules. You can do those kinds of things. You can also have alternates that might step in if one has predeceased you, for example, or just not practically can do that. Then you can have someone else who would then step in as a next stage. Again, you want to be careful you don't make it too complicated, but you can have layers that would be involved. In terms of property, when you are an attorney for property, in terms of the property itself, when you're an attorney for property, you have to manage that property for that person's interests. And you can, if it's been the habit of the person to make gifts and support other people, you can continue to make those gifts, but you otherwise are dealing with the property for that person's own interests. And you particularly have to take care that you don't deal with property which is subject to distribution through their estate in a way that then changes the distribution of their assets, unless it's absolutely necessary that you sell off something for that person's own benefits and needs. I already referred to the beneficiary designations, that as an attorney, you cannot make beneficiary designations with the qualification that, again, the financial institutions may be able to or willing to carry through an existing designation from one plan to another plan. It's not something which is an automatic thing that can be done. Generally, the attorney cannot make changes to beneficiary designations. And then last thing on the accounting. is that you are not required to, generally, you're not required to keep accounting records. And I say generally because if you're acting for someone who has capacity, then it's between the two of you what you might be doing as the attorney. But it's a good idea to keep records because if that person becomes incapacitated, then you might be stepping in and doing those things where you are no longer taking direct instruction, and someone who has an interest in that person's affairs, someone who is related, might ask for an accounting. They can apply to a court to ask for you to account for the things that you have done, and or when the person dies, the executor of the estate, even if that's you, someone could ask for an accounting of the activities that happened during the course of the person's life when there was an attorney who was operating. So it's a good idea to have that record keeping. Last point here is about compensation. If the power of attorney document is silent on the matter, then you are entitled to compensation, and it's in the regulations how much compensation you might be entitled to. There's a scale that's involved. I'm not going to go into it. It's about 3% of the assets, roughly. Um, but it can be more or less. It's just a guide that is there. And if the attorney says, or if the grantor says you're not entitled to compensation, then you're not. So it is something which does require effort, and so compensation might be quite appropriate. Michael, let's deal with the questions that come up.
Great. Thank you, Doug. The good news is that I think you've addressed many of the questions that were submitted in advance, so thank you for that. I wanted to start with a fairly, I think, straightforward one, and I know you touched on it in the presentation, but perhaps you can elaborate whether or not a lawyer is required to actually draft up the POA document, and if not, the alternative, and correct my terminology here if I'm not using the right terms, but I know for wills, as an example, like a holographic will, right, could be handwritten.
Mhm.
Do the same rules apply when it comes to setting up powers of attorney?
Yeah, with powers of attorney, in order to qualify as a power of attorney, there is required text that must be in the document, and it must be in writing, either for the power of attorney for property or for personal care. Now, the extension of that, again, with someone who is operating under power of attorney, if there are other wishes the person has expressed about how to go about doing these things, then the named attorney does have to take those things into considerations, whether they're in writing or just verbally stated. But it's in terms of the legal authority of the named attorney to act as attorney, you have to have the minimal documentation, minimally the text that the legislation requires in the document. And so it does not require that a lawyer be involved at all. It could be done. In fact, the Ontario Attorney General's office, I think it still publishes a power of attorney kit for both purposes, power of attorney
Hmm.
for property and personal care. I'm pretty sure that they still do that. You can use theirs, or you could have uh, your own. If you wanted to type the whole thing out, you could do that. So you don't have to have a lawyer involved in doing these things. It's just generally my general comment is that it's not something that as an individual you do with any regularity, and you are giving someone very significant legal authority. So using a lawyer makes good sense, in my opinion, so that it's done right, and you're not going to be constantly doing it over and over again. But if you want to do it yourself, then you can do that. You do have to comply, though, with the content and the execution requirements with witnessing as well. Two witnesses, as I said, are generally
Right.
required.
Right. Okay. And just to expand on that, somebody just asked a question in the live chat. Um, some banks or financial institutions also have their own internal forms, if you will, for power of attorney, but those are very specific in nature, as I understand it, right? They
Yeah.
a general power of attorney would, and correct me if I'm wrong, would potentially supersede or override any bank issued or financial services. issued.
Yeah, so yeah, general power of attorney gives the named attorney authority, whatever the scope of authority, as long as it's not illegal, the things that are suggested that the attorney will do. The general power of attorney allows the attorney then to deal with arguably all of the financial and property matters of the person who is the grantor. A banking power of attorney will only deal with the assets under the control of that particular institution. And in fact, you want to be careful that it may only deal with, again, banking, credit union, all financial institutions have different parts of the organizations, and particularly banks, though, because they're monolithic organizations. They may have a power of attorney that they want for you to execute, but it may only apply to their subset of the financial relationship you have with the broader organization. And they're not short documents generally. So it's kind
Yeah,
of difficult
yeah,
to make sure about that, but be aware that it's constrained in some way, certainly to the organization
yeah.
itself.
Yeah. So the next question, Doug, and I'll kind of try to not combine two, but I'll segue from one to the other. Um, Going back to a comment or points that you were making on assigning more than one individual as a power of attorney. And I know there's very different variations of that, whether it be joint or joint several or so on and so forth. If you could expand a bit on that, in the event, let's say, for example, that there is a disagreement between two attorneys on
Mhm,
medical care, as an example.
mhm,
What happens in that event if they are required to both jointly
mhm.
agree?
One thing I should mention about, or I should have stated, and I'm pretty sure I did not, about the power of attorney for personal care, as distinguished from the power of attorney for property. A power of attorney for property can operate either while a person is capable or can continue continuing is the term that tends to be used in Ontario,
Yeah,
which is again the equivalent of enduring and durable. Property power of attorney can operate while someone is capable or incapable. Power of attorney for personal care only applies after a person is incapable or unavailable, unconscious, to give instruction themselves. At that point, then there's leaving aside powers of attorney. There's legislation, the consent to treat. No, the Healthcare Consent Act, I think, is the term, is the phrasing now. There was a series of legislation that took over from one from the next. I think it's Healthcare Consent Act right now. It says that if someone is a court-appointed guardian of the person, that's who gives the medical instruction. If there is no such person, then you go to the attorney, one or more. And then if there's none of those, then you go to spouse and you work your way down the practically family members. At the attorney level, the power of attorney document hopefully will state in it clearly whether the authority is joint or joint and several. But practically, if I'm a medical practitioner, if I'm a doctor and I'm asking for consent to do something which has serious implications, then I really don't want to get a 2 out of 3. I want clear instruction from who's involved here that I can proceed, and I don't want to get caught up in some kind of disagreement. If there is urgent need, the person's life is in issue immediately, then healthcare professionals will do what is necessary in that circumstance. Get the guidance as they can, but they will act in the appropriate ways if it's absolutely urgent, immediate to take action. So if there is a disagreement among the attorneys at that level, and if it's not something which is literally life and death at that point in time, then the hospital or the medical organization will have some type of a process. They're required to have some type of process for the situation to be reviewed and for them to then come to a determination as to what should happen. If it elevates from there, then yes, it could end up in court to argue these things. But hopefully, there would be enough of the guidance from medical professionals who obviously have the knowledge to give as much guidance as they can, and that among them they can come to a resolution of how to approach the situation.
perfect. So Doug, just segueing from there, you referenced a few times the capacity of the person issuing the power of attorney. Now, what happens in the event that the attorney themselves becomes incapacitated? Let's say both donor and attorney are incapacitated, and there's no
Mhm.
alternate named in that power of attorney. What happens then?
Yeah, that's a I mean, you actually named the next thing that ideally would be in place is that there's somebody who is an alternate. And it's an important distinction to be made for people who have some understanding, dealt with these kinds of issues, that they may know that if a person is acting under will as executor for another deceased person, and if that person as executor becomes incapacitated or dies, then the attorney of the executor or the executor of the executor may step in to carry on the executorship. But that doesn't apply on powers of attorney. If an attorney becomes incapable, then that person is out. They're not involved anymore. And if there's no alternate named in the power of attorney, then you're in a position where a court application may be necessary in order to
Okay.
name someone else. And assuming everyone gets along, but there's extra care being applied if the attorney who's incapacitated, that person's attorney, spouse perhaps, is the appropriate person to then step in on behalf of that person to take care of their now mother-in-law or father-in-law, let's say, who's the first person that we were talking about, then the court application might actually say that. It's just that you can't immediately do that based on the way that the law of powers of attorney operates. So hopefully it would get resolved and sped through the processes so that the person could act, but it can't be under the power of attorney. It would have to be a court application.
Okay, perfect. Just wanted to make note. I know we're getting I'm seeing my chat box popping up with notifications. Unfortunately, we will not be able to address everyone's questions as we are almost at time, but we'll do our best to get through a few more. Doug, this was an interesting one that was submitted in advance when it comes to powers of attorney, with respect to online banking. Are powers of attorney who are acting on the financial needs of the donor, do they do they need to establish their own login credentials with the financial institution, or do they use those of the individual on whose behalf they're acting?
I don't know the answer to that. I'll throw that back at you, Michael.
That's an
I don't
interesting
know
one because
the
I'm
answer
not.
to that
Yeah,
because practically, I'm sure that happens fairly regularly. That we log on and we do things of our own finances, and we can do it for our elderly parents sometimes.
right.
And whether that's done under power of attorney or it's done to assist the parent, it is done fairly regularly, I'm sure. I don't know what the law is around that, whether it requires that that person have a separate login.
Okay. No, that's an interesting one. I've not encountered that myself, so I figured you'd know if anyone. Okay, last question, Doug. Somebody was asking if you could expand on the springing concept that you were discussing
Oh yeah,
earlier.
I saw that message. I was just scrolling through, and I apologize that I just used the word without explaining what springing meant. The idea of springing is that you want for the person who is acting as your attorney only to act once you are incapacitated. The problem is that then it springs into force only at the point that you're incapacitated. Sounds like a good idea, except how do you come to the determination that you cross that line from capacity to incapacity? And so, as I said, in some provinces, and the one that I mentioned about Manitoba, you can do a springing power of attorney, and there is a process involved where it needs to be verified, but it's a streamlined process that the power of attorney in the first place has a lawyer as a witness, so there's more officialness to it, oversight, and the process of verifying the person has become incapacitated is stated right there in the document. It's practically much more difficult if there is no test level that says that the person is incapacitated. Having gone through myself, not myself personally, but with one of my parents, we needed to get an assessment done, and there is a list of assessors through the Ontario government who will come and see a person who is purportedly incapable. It's not an impossible thing to do to have someone come in. But ideally, if you're going to have it only spring into force at the point of a person's incapacity, you will, one, be aware, and a lawyer who's actively in practice would have knowledge of how it is you would incorporate some phrasing of that nature and the process that you use to then have it corroborated or have it confirmed. Before then, the attorney would then be able to act comfortably under that document. In a lot of cases, you will have the person, like the daughter, for example, taking care of her mom hand in hand, side by side for months or years, perhaps, and then mom's slipping away in terms of her capacity, and daughter just continues to do those things. It's really not clear where the line was where incapacity arose, and it's not problematic in a lot of cases. But if it was something where there was more tension, then you'd want to have a clear line as to whether the person is acting as attorney or just as an assistant of some sort at various stages in the relationship and the person's decline, perhaps.
Great. Well, Doug, thank you. We are over time right now, which I'm not surprised. I know this is a very important topic. It could be a sensitive topic, and I do hope that today's session with Doug did help to bring a bit of clarity and confidence to everyone's planning process. Just a note: these webinars are meant to be informative, but they are general in nature because we aren't able to address very specific questions or specific case scenarios in these. And I understand that there's a lot of questions that might still be unanswered. And so I wanted to remind the audience that you can always email us at wealth@alterna.ca. Or better yet, if you do have an advisor with us, please connect with them directly and they can help walk you through the process and answer any questions that you might have. If Before we wrap up, though, I did want to also issue a couple reminders. I believe I mentioned this at the top of the session. You will receive some material from us in the days following today's webinar. There will be a short survey included in that, and we really truly appreciate any feedback that you can provide us, as it does help us continue to deliver these webinars and engaging topics that are relevant to everyone here. Today's session is recorded, and that recording will be shared with you shortly as well. It'll be posted on our website. And the final reminder is I wanted to let everyone know that our next scheduled webinar is on Thursday, October 16th at 3 p.m. The topic is still being finalized, but I do assure you it'll be another valuable session for everyone. So stay tuned for more details on that. Doug, thank you very much again for a great session, and thank you to everyone on the line with us for joining us today. I'd like to wish everyone a wonderful evening, and welcome back to our webinars.
Thanks.
Thanks, everyone.
Bye, Tom.